Straight ahead on Law and Crime Daily. A guilty verdict is handed down in the Sarah Lawrence College cult federal trial.
Perhaps in Larry Ray's mind, these videotapes were records of confessions that would somehow exonerate him, but that's not how the jury viewed it.
Plus,
we've learned of the very tragic death of Amara Marluke, a student here at Portland State University.
A one-time Portland State University football player is charged in the death of another student. And the state calls a rebuttal witness as the defense wraps up its case in the Olympian attempted murder trial.
When I first met with him, he was very, very tearful. I mean, he was crying uncontrollably. He almost at times was hard to console him.
But first, no charges are filed in the shooting death of 22-year-old black man Amir Locke.
It would be unethical for us to file charges in a case in which we know that we will not be able to prevail.
Law and Crime Daily covering court cases from coast to coast. Welcome everyone to Law and Crime Daily. I'm your host, Brian Buckmeyer. Minnesota officials announced no charges will be filed for the officers involved in the shooting death of 22-year-old Amir Locke. Locke was killed in February of this year when officers performed a no-knock warrant at the apartment where he was staying. Body camera footage shows officers entering the room where Locke was sleeping on the couch. Next to him was a handgun that he legally owned. Within seconds, Officer Mark Hanman shot Locke. He died as a result of his injuries. At the time, officials were searching for Locke's cousin, 17-year-old Mackay Speed, who was wanted in connection to a murder investigation. Speed has since been arrested and charged with second-degree murder. On Wednesday, Hennepin County Attorney Michael Freeman and Minnesota Attorney General Keith Ellison announced no charges would be filed in Amir Locke's death. They did acknowledge Locke's name was not on the no-knock warrant and that he was a victim in the shooting, but say Minnesota's use of force statute would not support charges in the shooting.
One thing Amir was not a suspect. Our investigation found no evidence that he had any role in the homicide investigation that brought the police to his door at 6:48 on February 2nd. Amir was a victim. He never should have been called a suspect. We have determined that under the precedent and the laws that we have, we cannot file criminal charges. Current law only allows us to evaluate the case from the perspective of a reasonable police officer. And that language is from the Fourth Amendment of the U.S. Constitution and relevant cases and statutes. We're not allowed to evaluate the case from the perspective of the victim. With all of the available evidence, we would not be able to prove in court that Officer Henneman's use of force was not authorized under the law beyond a reasonable doubt. It would be unethical for us to file charges in a case in which we know that we will not be able to prevail because the law does not support the charges.
Ahead of Wednesday's press conference, Minnesota officials revealed no charges will be filed through a press release. After that, Law and Crime Network contributor and podcast host Lieutenant Sean Sticks Larkin appeared on Dan Abrams Live to discuss why he believed parts of the release were misleading.
They talked about having paramedics basically present or on standby, and it just talks about the foreseeable violence from this type of search warrant. I have been on, honestly, I'm going to guess somewhere between 500 and 1,000, 800 to 1,000 search warrants over 25 years. We had paramedics present on every single search warrant we went on, whether it was for narcotics or for a homicide suspect, whether we're looking for burglary loot. We have paramedics present because there is always a likelihood that a shooting or an injury could occur on a search warrant. And just the wording in their release, again, made it sound like they anticipated or were looking for something like this to happen is why they had paramedics present. We always have them present. Police officers are almost always the bad guys. I believe you said it. There were other people present in this apartment when the police served a search warrant. They didn't point a gun at police officers. The police officers were not forced to use deadly force against them. It's just, we just kind of keep on catching this no matter what happens.
Joining us today is the civil rights attorney for Amir Locke's family, Jeffrey Storm. Jeff, why do you think charges should have been filed, and which ones, if any?
You know, Brian, based upon the facts that we saw here in the video evidence, we have a situation where from the outset, the officers come in, they don't announce before they breach the threshold, they encounter Amir. He's obviously asleep, and the officers, based upon policy and training, are supposed to be cognizant to barriers of understanding. And so clearly, if someone's asleep and jarred awake, they need an opportunity to understand what's going on. Here, there was a series of muddled screaming going on around him, and it actually took kicking the couch to wake him up. Given that he was given no opportunity to save himself, and he was someone who was a lawful gun owner and had his gun within arm's distance while he was sleeping, which is very common. So here, the jury, at a minimum, should have been given similar charges to what we saw Kim Potter ultimately get convicted of. At the very least, second-degree manslaughter for culpable negligence, and then first-degree manslaughter for a reckless use of a firearm resulting in death.
Now, Jeff, I know it's a different state altogether, but do you think the recent acquittal of Brett Hankison had anything to do with A.G. Ellis's decision not to go forward?
Lawyers always look at precedent. I honestly don't have any great insight as to whether or not it did. What I'll say is there are obviously a number of competing political factors here in Minnesota that create more than enough issues that could influence a decision maker.
All right, so no charges for the officers. We just heard that. But can the city be held accountable for Locke's death?
Absolutely, and so can the officers involved. Obviously we're involved because we're civil attorneys. And one of the ways the city can be held accountable is through a claim for unconstitutional policies and practices, which we don't have enough time to go through. The number of unconstitutional policies and practices that have been reflected by the Minneapolis Police Department. As it stands now, the Department of Justice is doing a policy and practice investigation. And I think the likelihood is very high that ultimately a federal monitor will be appointed to run the Minneapolis Police Department. And Amir's killing will only, I think, make that happen faster.
All right, thank you, Jeff. I know that your time is precious, but we appreciate you being here with us, and we hope to see you again soon. Still ahead on Law and Crime Daily, a Portland State University student murdered as another student is arrested in connection to the case. But first, the defense may soon rest its case in the Olympian attempted murder trial. When you could expect to see closing arguments next. Welcome back to Law and Crime Daily. The defense rests its case in the trial for ex-Olympian Michael Barisone, accused of attempted murder in New Jersey. The state, in turn, calls a rebuttal witness. Barisone is facing 2 counts of attempted murder after he shot Lauren Kanarak in the chest twice and shot her then-boyfriend Robert Goodwin back in 2019. The dispute followed ongoing back-and-forth arguments about Kanarak and Goodwin's living arrangement on Barisone's farm. At the time of the shooting, the two were living in an apartment on the property while Barisone trained Kanarak in dressage horseback riding. Barisone's defense team argued he feared for his life at the time of the shooting and even suffered from mental health issues. On Wednesday, defense called a psychologist hired to evaluate Barisone to the stand. During his testimony, he told jurors Barisone had told him he believed Kanarak had declared war on him. The prosecution then called a forensic psychologist as rebuttal to Barisone's psychiatrist testifying. He told the jury about the time he spent with Barisone.
Do you know how much time you spent with Michael Barisone in this case?
Yes, I spent 13.25 hours.
What was his demeanor when you met with him?
Well, when I first met with him, he was very, very tearful. I mean, he was crying uncontrollably. He almost at times was hard to console him. He was very upset about the whole thing, and he became animated at times, particularly when discussing Lauren and Robert Goodwin and the whole circumstances with respect to that. He would stand up, get animated, and so on. He was very emotional about it, but he calmed down and he participated fine. He was cooperative completely. He answered my questions, except for some resistance towards the end.
Joining us today is criminal defense attorney Nima Rahmani and co-host Terry Austin. Nima, the defense flew through their case, but what points did they raise, and did any make you think, I think there's some reasonable doubt here?
I don't think the defense case did much to move the needle here. I know the conventional wisdom in a temporary insanity case is you got to call these experts. Defense called theirs, the state called their psychologist. I think they washed each other out. The reason you don't need it in a case like this is it's very rare for someone to take 2 to the chest and survive. This case was about Lauren and Rob's testimony. I thought Lauren testified okay. I thought Rob testified poorly. This is a case based on cross-examination, and you never know what a jury is going to do when it comes to self-defense.
Right, I would tend to agree. Maybe not much from the defense, but closing's now being scheduled for Monday. The prosecution did put forward a rebuttal case. Terry, how do you think that went?
Well, the rebuttal was all about those medical experts. Dr. Simmering was the defense psychiatrist, and he's the one who said that Barisone was delusional, he had chronic depression. And then Dr. Hansen, he was the one who was the psychologist, and he basically said for the defense that Barisone did not know the difference between right and wrong, and that he didn't know the nature and quality of his actions. The rebuttal witness basically refuted all of that. He said while he respected Simmering, he didn't agree with the diagnosis. And so I think he basically refuted what the defense expert said. We'll see what the jury thinks.
Yeah, I think this is all going to come down to the closing arguments. And of course, the Law&Crime Network has you covered for gavel-to-gavel coverage. Make sure to check that out because I think that's the only way we're going to figure out how this all ends. Switching now to Ohio, where closing arguments are delayed again in the trial of former ICU doctor William Hussell. This as an affidavit seeks to remove the judge in the case. Closings were originally slated to be presented on Monday of this week, but have been delayed 4 times. Law&Crime Network has reached out to the judge's staff attorney in the case, who only says there are, quote, issues being worked out, but wouldn't say more. But on Thursday afternoon, local station WOSU reported that an affidavit of disqualification was filed to remove Judge Holbrook. The Ohio Supreme Court later denied the request. Hussell's accused of murdering 14 patients while practicing medicine as an ICU doctor at Mount Carmel St. Anne's Hospital in Columbus, Ohio. As of now, closing arguments are set to be presented on Monday, we hope. Coming up on Law&Crime Daily, more than 10 years after he moved onto the Sarah Lawrence College campus, a verdict is handed down for defendant Lawrence Ray. Plus, the lives of 2 Portland State University students are changed forever when the body of one student is recovered and another is arrested. Welcome back. A former Portland State University football player is arrested after the body of another student is found just off campus. On Monday, officials say the body of 19-year-old Amara Marluke was discovered. Her death was ruled a homicide, and the cause of death was determined to be a gunshot wound. Later that day, 20-year-old suspect Neenan Harpole turned himself in to the police. He was arrested and has since been charged with second-degree murder and unlawful use of a weapon. Investigators believe that the shooting was part of a domestic violence incident, but haven't released many more details. In a video statement, the president of Portland State University called Marluke's death a terrible loss.
We are so saddened about this horrific event. At a moment like this, a president doesn't have the full words or capacity to express the heartbreak, the sadness, and the mourning that's taking place for the loss of this amazing student. We try our best with the words that we have, but it's in our hearts, in our minds, where we feel the loss. Amara was an amazing student who cared about family and community. She will be so greatly missed, and we're so sorry. We wish our heartfelt, deepest condolences and sympathies to the family and to all those people whose lives she touched who will feel this terrible loss.
Criminal defense attorney Nima Rahmani and co-host Terry Austin are back as we break down this tragic shooting and loss of life. Nima, is it an open and shut case with Harpole turning himself in? If not, what more do investigators need to put forward to close this case?
Brian, it's a very strong case. Every time law enforcement arrests someone the same day, you know it's strong. We don't have all the facts yet, but clearly there was a gun involved. There was some domestic violence situation, at least because he has been charged with that. And we know when a young woman is killed, almost half the time, it's going to be a boyfriend, husband, partner, something to that effect. So I expect more evidence to come out in the coming days and weeks, and I expect Harpole to be convicted or to take a plea because it seems like a very strong case so far.
Yeah, it's interesting because that's part of my question here. So, Terry, we've got a confession, or at least we were told one. I'm looking for this smoking gun, and if those two are put together, do you see this going to trial or Harpole taking a plea?
Here's what I think, Brian. I think initially it will go to trial. There's no question because he turned himself in, but he also initially pled not guilty. So he may try to assert a defense, Maybe he'll say that it was a crime of passion. But ultimately, Brian, I do think he'll probably have to take a plea based on the evidence because it does seem strong so far based on what we've seen. He wasn't released on bond. He's in jail. Maybe being in jail behind bars will make him get to a point where he will want to take a plea, particularly if that evidence is so strong against him. And we heard the parents and the family talking about this terrible tragedy. So I do think that there will be some pressure to take a plea.
Yeah. Maybe a false confession argument. I don't know. But if I'm looking at the facts of the case, and as Terry, you said, he's still incarcerated, I'm thinking this is going to be a plea and we're not going to see much of a trial here. But of course, here at the Law&Crime Network, we'll keep eyes on this case and update as it develops. When we come back, after weeks of testimony, a verdict is returned in the Sarah Lawrence College sex cult federal trial. Still ahead, hear from Law&Crime Network's Adam Klasfeld, who was at the courthouse when jurors returned. Welcome back. A jury is seated in Florida where an ex-physical therapist will soon be tried for the murders of his wife, 3 young children, and family dog. It happened in early 2020, just miles from Disney World in Celebration, Florida. That's where prosecutors say 45-year-old Anthony Todt murdered his family. Investigators found their bodies days after they were killed when officials attempted to arrest Todt on unrelated charges of insurance fraud. In a jailhouse letter to his father, Todt claimed his wife was to blame for the killings. Stay with the Law&Crime Network for gavel-to-gavel coverage of the case. Live coverage will begin with opening statements. They're set to be presented on Monday. And a verdict is reached in the Sarah Lawrence sex cult case in New York City. The 62-year-old defendant, Lawrence Ray, could spend the rest of his life behind bars after being found guilty on a 15-count indictment of federal charges. Law&Crime's Adam Klasfeld joins us with what it was like the last few weeks inside the courtroom.
It was a very quick verdict. Deliberation started at 9:30 in the morning, and by a little after 1, we received a notification that there's a verdict, and the verdict was what it was. Guilty on all 15 counts of sex trafficking, racketeering, forced labor, extortion, money laundering, and other crimes. The prosecution said during summations that he acted like a crime boss in victimizing these Sarah Lawrence students whose lives he entered in 2010. U.S. Attorney Damian Williams for the Southern District of New York described how he exploited them, tortured them. One of his victims, Claudia Drury, was 19 years old when they met, and she testified that he coerced her into a life of sex work to pay back debts of $2.5 million to Larry Ray. A very grueling testimony. She was on the stand for 5 days. In the courtroom when it went down were the Rosario siblings. Even their mother, Maritza Rosario, testified about not seeing her children for years. We saw the video, of course, of Dan Levin having his tongue pulled with a set of pliers by Ray. That is just some of the harrowing testimony of what he subjected this group of kids to. And now the verdict is in. The jury believed their own eyes. They believed what they saw in the videos. They believed what they heard in the audio tapes, and they followed the money trail. So a very sordid case, 15 counts, a very complicated case, but it didn't take the jury too long to bring it to its conclusion.
Adam, we cannot thank you enough for bringing this case to us and spending so much time there in federal court. Lawrence Ray is set to be sentenced in September, but there is one more trial to go into the case as Ray's alleged co-conspirator, Isabella Pollock, also faces federal charges. Nima, one person, more than anyone else, is probably watching that verdict and is terrified. And I'm talking about Isabella Pollock. What do you think this verdict means for her?
Yeah, Pollock and attorneys really got to take a look in the mirror. When a jury returns a verdict in 4 hours, you know you're in trouble as a co-defendant. And there's so much testimony in this case that's just so horrific for the defense. And there's video and there's notes. And we're looking at a 15-year mandatory minimum, potential life sentence. So if I'm Pollock, I do everything I can to plead to something, maybe as a minor role or do something to get out of a mandatory minimum. Because if she goes to trial, she's going to suffer the same rate as Ray and likely going to spend almost the rest of her life in federal prison.
Yeah. Now, Terry, we know the general ranges for sentencing, but we also know the severity of this case. So now that Ray was found guilty on all counts, what type of sentence do you think he will receive?
Well, I think it's going to be on the very high end of all of those sentences. Look, we know it's between 15 and life. And if you look at the aggravating factors and the mitigating factors in this case, the aggravating factors far outweigh any sort of mitigating factors. We know that he was previously charged and convicted. We don't know whether or not he's served anything in the community as far as being a good person, but we saw what happened with those videos. We saw all of the different victims that he really did torture. And we know the families have been impacted by all of this. So I think at the end of the day, when he is sentenced in September, we're going to see the maximum imposed, if at all possible. This is not the type of person that you want to see back out on the streets at any point in time. He really is a danger to society, and I think that the judge will come down hard on him.
Yeah, I would tend to agree, especially when I'm thinking about these impact statements that we're likely to hear. Well, thank you both for joining us, and thank you for joining us here at Law and Crime Daily. We'll see you next time as we discuss justice in America.